us to look at termination. Termination is a very sensitive topic because this is where advocates get a lot of litigation. At the end of the day, somebody was fired, but the procedure was not followed, or they feel their termination was not proper. So there are various ways of terminating an employment contract. One of them being resignation, the other one being summary dismissal, redundancy, end of probation, mutual agreement between parties, expiry of a fixed term contract, and also retirement. Now, Section 44 provides for summary dismissal. So many of us ask ourselves, what is summary dismissal? What's the difference between redundancy and the summary dismissal? Now, I want us to look at summary dismissal. It's covered under Section 44 of the Employment Act. Summary dismissal occurs when an employer terminates the employment of an employee without a notice or with less notice than the employee is entitled to. Now, a person who is summarily dismissed is not entitled to any benefit. That's one thing we're supposed to note. However, entitlement to a person who has been summarily dismissed, unless he has evidence otherwise to prove that he's entitled to any benefit, he should not be given anything. Here we have the famous case of Fred Makori Odari versus the Management Committee of the Ministry of Work Sports Club. The court says that if somebody has been summarily dismissed and they feel they're entitled to any benefit, the burden of proof shifts to them. The following are reasons that may lead to summary dismissal. We have absenteeism without lawful cause or leave. We have intoxication, rendering a worker incapable of performing his duties. Those people who are fond of going to work after they have drunk. Then we have willful neglect of duty. We have use of abusive or insulting language. We have refusal to obey lawful instruction. Where the employee has been arrested of a cognizable offense, punishable by imprisonment. And this imprisonment is for more than 14 days. Then we have where the employee commits a reasonable ground where an employee commits or on reasonable ground is suspected to have committed a criminal offense or against the employer or the employer's property. These are grounds for summary dismissal. So when one of your employee commits one of these offenses, then you are at liberty to summarily dismiss them. We have redundancy. Redundancy is captured under Section 40 of the Employment Act. This one, I'll urge employers, especially where you know you are winding up a company or you are running bankrupt. This is something you need to consider very well because this is where we have a lot of labor disputes. Now, redundancy means the loss of employment or occupation or a job by involuntarily miss or through no fault on the part of the employee. So the employee has done nothing, but you are becoming bankrupt, you can't afford the year salary. You have to close close down the operations. You have to wind up a company, so the employee, they have to go home. So what is the procedure for redundancy? First of all, you are supposed to do consultation with the affected employees at least 1 month before the intended date of redundancy. After that, you are supposed to issue them a notice of the intended termination due to redundancy to the affected employees, at least 1 month also prior to the date of the intended termination. This notice, kindly note, it should be served also to the labor office of the designate place of where the company is located. And if employees are also members of a trade union, the trade union should be served with the same notice. Kindly note that after this notice, now it is now when you issue a letter of the actual redundancy, and it should be issued 1 month after the first notice. You are also supposed to serve your, give your employee certificate of service as provided under Section 51 of the Employment Act. Now, there's something I want us to discuss briefly. I want us to also look at various cases. In 2017, there is an employee who sued Catholic University. The case is known as Lydia Mbuthia versus Catholic University of Eastern Africa. It was the issue of redundancy, and the court awarded damages of 3 million. But basically what happened is her position was declared redundant, and after she was asked to go back and to continue lecturing, because this was a management position, 1 week after that redundancy, the university advertised her position and they recruited somebody else. Lydia went to court and alleged unfair termination and said there was no need of redundancy because they simply got somebody to replace her. And she was in a position to be compensated 3 million. So employers, I want you to be on the lookout. Some of these minor things are the ones which land us to court and we end up paying a lot of money. So that's what I was telling you. When you declare a position redundant, kindly do not re-advertise and replace that person. Also, when you are doing redundancy, it is paramount to note how do you exit your employee. The law provides that last come, first out. So those are some of the principles I would want you to observe.